Is the telephone Tristan?
Yes, ma'am.
All right, thank you. And I believe Tristan, I turned on the system, just wait. I believe Tristan, you've done all that you need to do. They got your DNA, they got your fingerprints, all of that fun stuff.
I believe so too.
All right, thank you. We will go on the record
Thank you.
in the matter 22 CF 93, State of Wisconsin versus Tristan Ankeny. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Ankeny appearing by telephone conference with approval of the court. We have his counsel, Michelle Erdman, appearing by video conference. We're set today for a plea and sentencing hearing. Before we begin, Mr. Ankeny, you are appearing by telephone and your attorney is appearing by Zoom, via video. And you have requested to appear this way, is that correct?
Yes, ma'am.
And do you understand that you have the right to be here in person if you wish?
Yes, ma'am. Logistically, it's not feasible.
And I understand that. I just have to ask this. I have to put it on the record for appeals purposes, that kind of thing, okay? So do you understand that if you have any questions or you have any concerns, I will send you both into a confidential breakout room so you can discuss anything that you wish with your attorney, okay?
Okay.
All right. Ms. Erdman, the parties have reached an agreement. Can you please recite the agreement for the record?
Judge, we filed a plea questionnaire some time ago. It was document number 46. Mr. Ankeny is going to be pleading to 3 misdemeanor level charges today. Misdemeanor possession of amphetamine, possession of a controlled substance, and then possession of THC. And Your Honor, the parties have agreed that he would be on 2 years of probation, and the standard terms of conditions of probation, including AODA and follow through and complete any programming that he's enrolled. I think that's kind of expired since the prior agreement was entered, but we would expect if he is ordered to do any, or if his probation agent feels anything would be useful, that he would follow through with that treatment as well, Your Honor.
All right, thank you. And Mr. Ankeny, you live in Richfield, Minnesota, is that correct?
Yes, ma'am.
And that's on West 72nd Avenue?
Yes, I believe. It's either Avenue or Street.
Okay, thank you. All right, and so he'd be pleading to 3 misdemeanors and we're asking him to stay on Burnett County probation?
Yes.
Okay. And so, Mr. Ankeny, do you understand, and before I get into taking your plea, I just want to make sure that you understand that if the court does follow the recommendation and does place you on a period of probation, that it would need to be through Burnett County office. It cannot be transferred, most likely, because of the interstate. Now, the interstate compact, they have agreed or they do not wish to accept misdemeanor pleas for their probationary review and oversight. So do you understand that you would sometimes maybe need to come in person to Burnett County to your probation agent?
I did not understand that. I'm hearing it now, and that sounds kind of difficult. It took me 2 years to get up this last time.
Okay, so I can't guarantee that they won't transfer it. I can't guarantee that they will transfer it, but there is a possibility that you may at sometimes need to come in person for some random drug screening. You may not. I'm not the Department of Corrections. They may have you just do Zoom appearances. I'm not sure. I just want to make sure that you understand the ramifications of having a probationary recommendation.
I'm beginning to. Thank you.
All right. So at this time, would you like to have a little breakout session with your attorney, or do you feel comfortable enough to proceed with the plea and sentencing?
I don't want to waste anybody's time here. Let's roll.
Let's roll. Okay. All right. So I do have in front of me a plea questionnaire waiver of rights form, and you did sign it some time ago on October 3rd, and it's 2023 because you were ready to plea and you were ready to be sentenced. But then for some reason you didn't appear and the court issued a warrant, and it was some time before you were I believe you were picked up on the warrant. Is that correct?
No, it's not. Well,
Um,
it may have been at one point, but he turned himself in. He wanted to get this matter addressed. So he came there. His dad gave him a ride back last month.
All right. So that's good to know. All right. So
Earlier
Mr.
this month.
Ankeny, this was signed on October 3rd, 2023. And Ms. Erdman, you're indicating that he understands everything. You went over everything on this plea questionnaire and everything is still accurate and true other than those other conditions such as the AODA and fall through because he's been through treatment, correct?
That, and I suspect he's probably gotten a little older, but other than that, I think everything should be accurate, Judge.
Yes, I'm going to guess he has since it is now 2025. Okay, Mr. Ankeny, how old are you?
91. I'm 34, I believe.
You're 34. All right, so you're 34. And do you remember accurately what is in this plea questionnaire and do you understand it?
Yes, it's basically dropping 2 felony counts down to misdemeanors and agreeing to go on probation.
Right, and it had a whole lot of other things on this, such as your constitutional rights and what you'd be giving up, and some other things. So your attorney went over this with you, is that correct?
Yes, ma'am.
And so you understand everything on this document?
Well, I don't think I'm that smart, but I get the gist.
Well, I need to make sure you are that smart, that you understand everything. And I'm going to go over quite a bit that's on this plea questionnaire. But when your attorney went over this with you, did you at that time understand what she was explaining to you?
Yes, ma'am.
Okay. And so I'm going to refresh your recollection. I'm going to refresh your memory and go over some of these things with you again, but not in exact detail. Okay.
Okay, thank you very much.
So you're pleading guilty to 3 misdemeanor counts. First, I have to ask the state formal motion to amend count 1 to possession of amphetamine.
So made.
Granted. So you're pleading guilty to possession of amphetamine, possession of a controlled substance, and possession of THC. Is that all correct?
Yes, ma'am.
You're 32 years old. You're 34 years old. You have 16 years of schooling. You can read, write, understand the English language. You have not had any drugs, alcohol, or other medications in the last 24 hours. Is that correct?
No, ma'am.
And you are currently receiving treatment for a mental illness or disorder. And would that be your substance abuse disorder?
Yes, and depression.
And depression. And so with your depression, are you in a place right now where you can fully understand and comprehend what's going on?
I am cognizant, coherent, and capable.
I'm very glad to hear that. Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on that document. I will briefly go over those rights with you to make sure that you understand what you're giving up. You will no longer have the right to a trial. You will no longer have the right to have your attorney cross-examine the state's witnesses or call witnesses to testify for you. You will no longer have the right to testify or to remain silent and not have your silence used against you. You will also no longer have the right to have that jury trial in which 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you will no longer have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up here today?
Yes, ma'am.
You understand that if you're not a citizen of the United States, your plea could result in your deportation.
Oof. Crazy times we live in, but yes.
Yes, but legally, and I'm told I must ask that question to everybody just in case, so you understand that you could be deported. And so it gives you an opportunity to think a little bit more carefully about your decision. So do you also understand that here, the state would have to prove as to the amended count 1, possession of amphetamine, that you possessed a substance, the substance was a controlled substance in an amphetamine classification, and that you knew or believed that substance was a controlled substance in an amphetamine classification. Do you understand what the state would need to prove?
Yes.
And do you understand the maximum possible penalty could be a fine of up to $5,000 or 1 year of incarceration or both?
I understand.
You understand as to count 3, possession of a controlled substance. The state would have to prove that you knowingly possessed diazepam, a controlled substance without a valid prescription. Do you understand what the state would have to prove?
Yes, ma'am.
Do you understand the maximum possible penalty could be a fine of up to $500 or imprisonment of up to 30 days or both? Do you understand that?
Yes, ma'am.
As to possession of THC, do you understand the state would have to prove on or around April 10th, 2022, that you knowingly possessed a controlled substance, THC? Do you understand? And do you understand what the state would have to prove?
Yes, ma'am.
Do you understand the maximum possible penalty could be a fine of up to $1,000 or imprisonment of up to 6 months or both? You understand that?
Yes, ma'am.
Do you still wish to proceed and enter a guilty plea here today?
I do.
Do you have any questions for the court or for your attorney before I proceed?
I do not believe so.
You understand that there is a recommendation for the court to place you on probation with certain conditions. Do you understand I'm not bound by that recommendation?
I did not know that.
All right. Well, I'm telling you now. Do you understand that? That means that I could sentence you to anything that I feel would be appropriate in the circumstances, which could be a fine, it could be probation, or if I thought it was warranted, an aggravated case, I could sentence you to the maximum possible penalty for these crimes. Do you understand that? Is that a yes?
Yes, ma'am.
All right. Do you still wish to proceed and enter guilty pleas?
Yes, ma'am.
Did your attorney go over the criminal complaint with you? And there's a section called the probable cause section where it basically says what happened and why you were charged with the crimes?
If we did go over that, it's been a while.
And so do you recall that day and what happened? And so are you admitting here today you in fact did possess a substance in an amphetamine classification?
Yes, I guess. Yes.
Is that a yes? Or did you?
Yes, ma'am.
All right. And so you knew it was an illegal substance?
I did.
You, in
Wasn't thinking
fact-
about it much at the time, but yes.
I appreciate that statement. Did you also have in your possession a controlled substance and you did not have a valid prescription for that?
Yes, ma'am.
And you knew you could not possess that without a valid prescription?
Yes, ma'am.
Did you in fact possess THC, marijuana?
Yes. I do.
And you knew that that was an illegal substance in Wisconsin?
Yeah, I guess, yes.
Yes, it's illegal in Wisconsin.
I thought you
live
guys
in
had
Minnesota,
legalized
do what you
it.
want there. What?
Okay. I thought
right,
you guys
so
had legalized it by now, but
Oh, gee, no,
it's been a while.
probably not going to happen.
Hmm.
Probably
Well.
not going to happen. So if anyone believes that they can come here with THC, they cannot. So just kind of drive around, go on the bottom side of Wisconsin or the top side of Wisconsin. You're free to go. Just can't drive in Wisconsin or be in Wisconsin and have THC. Okay.
Good to know.
All right. So has anyone made any threats or any promises to you for you to plead guilty to these charges?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes, ma'am.
and voluntarily.
Yes, ma'am.
Are you satisfied with your attorney's services?
Yes, ma'am.
Do you have any questions for the court or your attorney before I proceed?
No, I have none.
As to count 1, possession of amphetamine, how do you wish to plead?
Guilty.
As to count 3, possession of a controlled substance, how do you wish to plead?
Guilty. Oh,
As
I'm
to,
sorry. I think I pressed a button. My bad.
that's okay. So what was your plea?
Guilty, ma'am.
As to count 4, possession of THC, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt based upon your admissions. The court will dismiss and read in count 2 and count 5. The judgment of conviction will be entered today. Argument and recommendation, Mr. Schmidt.
I think the probation is necessary in this case. I think Mr. Ankeny needs a little bit more help controlling his substance abuse issues. In this case, there are kind of 2 things that kind of concern me above the norm. One was him being with Patrick Stewart when he had heroin paraphernalia, showing him in the presence of someone with a much more dangerous drug. And 2, the presence on him of that modified flare gun that was set up to fire rock salt instead of a flare. That demonstrates that wherever Mr. Ankeny's substance abuse was going back then, it was taking places at least he perceived as being dangerous to himself. So to the extent I want to make sure he doesn't get himself in a position where he's in danger, I think getting a hold of that is important. Thank you.
Thank you. Ms. Erdman?
Judge, Mr. Ankeny has been someone who's gotten a hold of me repeatedly over the years, just trying to get this figured out and resolved. He's the one that proactively reached out to me and said, hey, I think I can finally figure out a ride. I've got my dad lined up. He came in, gave his DNA, got everything set up that way, made the appearance. He's been pretty diligent about trying to get this resolved, even though the challenges with transportation have been long. I do think that when I speak with him today, I hear a clear-headed young man that seems to be doing the right things. He's committed to, I think, staying out of trouble, addressing his issues, and he's definitely on the right path. So for those reasons, Your Honor, we just ask you to consider the recommendation.
All right. Mr. Ankeny, is there anything you want to tell me, anything you want to say, anything you want to let me know?
Yes, actually, I'd like to make a statement to the court.
I would love for you to make a statement, and I'm going to tell you I would like to hear a few things too in that statement. Like if you're on probation in Minnesota, any kinds of treatments that you had, your sobriety date, those types of things, okay?
Yeah, I was actually going to address all of that.
I am so happy to hear that. You go ahead.
I keep pushing buttons. I apologize. Let me start with this. I have chronic pain and health problems. I've had 5 major hip surgeries. I've been dealing with an opiate addiction for the entirety of my adult life. So you, Mr. Schmidt, you were concerned that my addiction was going down a dark path. I am excited and happy to inform you that I am on a better path now. I'm in a much more stable living environment, and my addiction is much more under control. It is not entirely managed, but I'm trying very hard to make it so. Let's see, I am not on probation in Minnesota. I have no other legal quandaries or quarrels with any law enforcement in this nation. And I have no priors. So I really am trying my best to improve my life, become a productive member of society.
These are your first convictions?
Yes, ma'am.
All right. Thank you. And tell me what you're doing with treatment and what you've done with treatment.
I'm not currently in treatment. I'm pursuing sobriety of my own volition and free will.
But you were in some type of intensive outpatient treatment, correct? Back in 2023?
I was. Have you heard of Evergreen?
I believe I've heard of it. I don't know much about it.
Rampant corruption, 40 million in fraud in under a year.
Oh, wow.
Yeah, that's where I was.
All right.
It wasn't great.
Okay.
Frankly, having absolutely no treatment is better than being at Evergreen.
Well, that's sad to hear. Do
It
you
is.
go to any meetings? Do you go to, or do you have a sponsor, anything like that?
No, frankly, I've found socializing with sponsors and other addicts has led to more addiction.
Okay. Why were you in Burnett?
I was visiting a friend and Patrick Stewart, first time I ever met him, and the last, hopefully.
I'm glad to hear that too. Now, Mr.
Yeah.
Ankeny, do you have any need to come into Burnett at any time?
Unless it's to give urine, no.
All right. So let's just say you're off of probation, all of those things. You have absolutely no need to come into Burnett County for any reason. And if you still have a friend, your friend can visit you in Minnesota.
Absolutely.
All right. Anything else you want me to know?
I hope you've been well and have a good day.
Well, thank you. All right. So this is I don't want to say this is a tough case with it's complex or anything of that nature. This is not a complex case. This is a case where we have an individual who has a substance abuse disorder, an admission to a substance abuse disorder. He's had some self-reflection. He understands his addiction, and he's been working very diligently to try and take control over his addiction. It sounds like he's in a much better place than April 2022, and he's with much better people than he was in 2022. This is your first conviction of any criminal activity or criminal charge. So there was not any bond violations in this case. The only thing is that when we had the matter set for a plea and sentencing, I believe way back, it was 2023. I believe it was supposed to take place on November 15th, 2023, and you failed to appear. And then a warrant was outstanding until just recently. But I do recall now you did come in and you turned yourself in for the warrant, and then you bailed yourself out, and you had your other court date, etc. That may have gotten a little confused because you didn't appear there. But then the court did quash it to allow you to get this matter resolved. It sounds like you're doing pretty well. It sounds like you've been trying very hard to stay away from the people that drag you down and bring you down the wrong path. And so that's something that's positive. Do you live with your father?
I'm afraid not, ma'am.
Afraid not? Where do you live?
I live in Minnesota. He lives in New Mexico.
Oh, I'm sorry to hear that. But it's good to hear that he was up here and helping you when he did. Do you live by yourself?
Yeah, I
or
got
do you
lucky.
have? Okay. And so you're working very hard on your sobriety, and I'm very glad to hear that. Knowing all of these things, I have not seen that you are a risk to the community, especially around here. You have no reason to be in Burnett County. You met Patrick Stewart one time. You have no intention on being around Patrick Stewart again. That is very good to hear. You need to stay with people that can help you with your sobriety, help you maintain your sobriety, not bring you down the other road. So I'm very glad to hear that. And knowing all of these things and looking at this with the totality of all of the circumstances, all of the things that I have to look at here, I'm not following the recommendation. I'm not going to place you on probation. I'm not going to set you up to fail, because if you need to travel to Burnett County and you aren't able to travel to Burnett County to do drug tests, etc., then you're going to get a warrant and you're going to need to have probation holds, etc., because it would look like you're absconding. It sounds like to me, since 2022, you have done things to get yourself in a much better place, and I'm glad to hear that. I do not want to see putting you into the system and having that actually do something negative. I'm going to believe you that you're continuing to do what you need to do. You're staying away from people that you should not be around. I'm going to trust that you're going to continue to do that. So I'm not going to place you on probation. I'm simply going to assess $250 per count. You have 700, did I do that right? Yeah, you have $750 posted. So that means you are good to go. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need to order your DNA. You've already provided it. Thank you. You have the ability to request that be expunged from the system through a written letter to the Department of Justice, not to the court, not to me, to the Department of Justice. I believe you have jail days. I don't know how much. How long do you think you spent in jail?
I believe 2 weeks.
2 weeks, and that's in the totality of this case from when it started?
I've got 18 days,
Yes, ma'am.
Judge.
All
Like
right,
from the
so what
very
I'm gonna
beginning.
do is I'm also sentencing you to 20 days of jail, time served, 18 days of jail credit.
Oh, cool.
All right, so I believe, again, 20 days to appeal. I think I've covered everything, Mr. Schmidt.
Nothing for me.
Ms. Erdman?
Judge, I think he can set up a payment plan with your clerk of court if he can't pay.
Oh, I
I'm
don't need
sorry.
money.
He's got the money on file. He's got money on
Yep.
file, so we're good. That's all. That's
We're
all.
good. All right, thank you.
Okay.
We are adjourned.
Oh, thank you so much, Judge. Very unexpected and very, very appreciated. Thank you so much.
Well, Mr.
I don't
Go ahead.
mean to be rude, but I hope this is the last of our interactions.
I hope so too. Mr. Ankeny, I sentenced you how I feel it is appropriate and sentenced you based upon what I've seen, well, what I've heard. I haven't seen you, but what I've heard you've been doing. I want you to continue down that path, and I don't want to create any obstacles for that. Do what you need to do. Stay in control of yourself. Take control of your sobriety and your substance abuse disorder. You're doing great. Keep it up.
Thank you so much.
All right. Thank you. We are adjourned, or we were adjourned. You don't have
Thank
to
you.
have that on. Thank you.
Have a great day. Thank you.
You too. Thank you. All right. Brandon Allen. It must be a waiver then, because I saw
Yes,
Captain
Your
come
Honor.
in and then Captain left.
Yes, Your Honor, and I would like to readdress bond.
It's okay. So he's in custody. I cannot see you. There we go. Is there any notice to readdress bond?
Your Honor, I believe it was mentioned at the last hearing that we had.
Does state waive notice?
That's fine by me, Your Honor.
We will go on the record in the matter 25 CF 98, State of Wisconsin versus Brandon Allen. The state appears through Assistant District Attorney Jose Vila in person. We have Joel Feliski in person. Mr. Allen appears by video conferencing in custody in Burnett County Jail. We're set today in this matter for a preliminary hearing. Mr. Allen, I've been informed that this is a waiver of that hearing. Is that correct?
Yes, ma'am.
Did your attorney thoroughly go over with you what it is to have a preliminary hearing?
Yes, ma'am.
I see, Mr. Feliski, you have proper document, and you went over that with Mr. Allen?
I did, Your Honor. I went over it word for word with him. May I approach?
You may. Thank you, Mr. Feliski. So, Mr. Allen, I have this waiver of right to preliminary hearing document in front of me. Did your attorney thoroughly go over this document with you?
Yes, ma'am.
And you understand everything completely?
Completely, yes.
And you understand that you are admitting that the state can meet the burden of probable cause?
Yes, ma'am.
And you understand that once you waive the right, it's forever and you cannot get it back?
Correct. Yes, ma'am.
Has anyone made any threats or any promises to you for you to waive this right?
No, ma'am.
You're doing so freely and intelligently and voluntarily?
Yes, ma'am.
I'll find that you are competent, you're freely, intelligently, and voluntarily waiving the right to a preliminary hearing. I find probable cause and bind the matter over. And Mr. Allen, this is your signature on the form, correct?
Correct. Yes.
All right. Information, Mr. Vila.
I'm going through and filing them now. They will mirror the criminal complaint.
Would you like to proceed with an arraignment or set for another date?
Your Honor, if we could set for an arraignment.
How far out? Well, I can do no, that would be wrong week. I can do October 1st. I have a couple slots in the morning, or I can do the afternoon at 2:30.
The time at 2:30 will work, Your Honor.
October 1st, 2:30. All right, we'll set that for an arraignment. All right, argument for bond modification.
Thank you, Your Honor. My argument essentially mirrors the modification request that was filed previously. The only update I really have is that I do want the court to know that Mr. Allen, it's my understanding as of yesterday, did complete the HSED program at the jail. I believe that he advised that he's actually the first male to complete the program at the jail. So he has been taking advantage of the resources available to him. He has been in custody for a significant amount of time on this case. The request for $2,500, Your Honor, is still a very, very significant amount of money. It is, I think, very sufficient to compel Mr. Allen to come back to court and to have this matter resolved.
First, before I ask for argument from the state, I just want to tell you, I am so proud of you, Mr. Allen. I'm proud to hear that. Congratulations. I really think that is an amazing accomplishment.
It is, Your Honor. Thank you very much. Yeah, I'm very, very excited about it too. My mom's excited. She's here. Yeah, it's been a long time coming, and I wanted to thank you for that opportunity as well. And without coming here, I don't think that I would have been able to achieve that. So, I mean, now I'll be able to kind of move on with my life and pursue after schooling. Hopefully.
I'm just so glad to hear that. I'm just so happy. All right, Mr. Vila.
Your Honor, the main concern here is the level of offense that Mr. Allen is currently charged with. There was 43 grams of meth that was found on his person. If the court is open to modifying the cash bond, the state would still request a significant amount of cash to ensure future appearances. He has one missed appearance, I believe, in Minnesota from 2016. He was in warrant status for 4 months during that time. But outside of that, it looks like he's appeared for court. So,
and I'm not sure who wants to provide this to me, but what is his criminal history?
Your Honor, for my review of CCAP, I don't believe that Mr. Allen has any criminal history here in Wisconsin. The only cases I found were, as DA Villar suggested, the 2016 conviction for, I believe it was...
it's a petty misdemeanor theft case in Minnesota, Your Honor.
Petty misdemeanor theft. And the only other conviction that he has on record is very ancient. It's 2011. I believe it was issuance of dishonored check.
All right. So, Mr. Allen, if the court considers modifying bond and amending it down to a lower cash, who's going to be posting that cash? Whose money is it?
Well, as of this time, I'm not for certain anymore. When I first filed for bond modification, I had a friend that was possibly going to bail me out. But at this point, it'd be kind of all hands on deck. If that day even came, part of it is for peace of mind at this point and to prove to the court that I will show up for a court. I think $2,500 might take me a week or two to talk with some of my friends if I can even get in touch with them. Family members possibly.
All right, here's what I'm going to do. And Mr. Allen, you getting your HSCD is coming into play big time. It's showing me that you want to change your life and you want to do better things with your life. And I want to see you do that. This is a very serious charge. I don't know the ins and the outs. I don't know how you were allegedly in possession of 43 grams of methamphetamine. I don't know anything other than what's in that complaint. But I do know that this is a serious felony. You face 25 years of incarceration, some initial and some extended supervision, that's a lot hanging over your head. Hearing that you don't really have a criminal history, or it's just a few things here and there, not anything along the lines of possession with intent of methamphetamine at almost 50 grams, that comes into play as well. I believe in the motion, you stated that you were going to be working at the Salty Steer and living with your mother. Is that correct?
Correct. I'm not 100% certain about working because, again, a lot of time has passed. But if you look at the area that my mother does live, very few options to work are available, and they are consistent with bartending, which I am licensed to do. I got no problem with checking in with law enforcement so they can see that I'm not in breaking any of the rules or anything like that. I got no problem with staying sober. I just want to get working. My daughters, I've received a few letters from child support agencies since I've been in here. They want to continue to pursue child support from me. I want to be able to attend those hearings as well. So, I might be able to try and take up a cooking job in a restaurant up the road. But like I said, with the location of where the living status is, very minimal places are accessible to work with, form of transportation.
His mom, can you please step forward? What's your name?
Deborah Allen.
Deborah Allen. Ms. Allen, do you understand that if the court does modify bond, one of the conditions will be to reside with you?
Absolutely. He's been living with me for 3 years.
Well, you need better supervision.
Yeah,
And so you're willing to take the risk and to supervise him?
absolutely.
Do you own your home?
I do.
So what I'm going to do is if I do modify and amend, and then I don't know what amount yet. My brain needs to think a little bit, but you're going to need to co-sign for a cash bond. And I would do a cash bond with part of it be a signature bond. Do you understand that if he violates his conditions of probation, he does any criminal activity such as this or others, that you could be liable as well? Are you willing to take that risk? Okay. And so if he doesn't come to court, that means that the court can convert that and could possibly go after you for the
Right.
remaining amount. You understand
I
that?
understand.
And you're willing to take that risk. Oh, all right. Thank you. You may go have a seat. Mr. Allen, do you understand the seriousness of this?
Yes, ma'am.
Do you love your mother?
More than anything.
Do you respect your mother?
100%.
Do you love your daughter?
The daughters, yes, ma'am.
Oh, daughters, sorry. All right, Mr. Allen, this is what I'm going to do. This is a serious risk because this is a serious felony and I am taking a chance on you. I will amend to a $2,500 cash bond with a $22,500 signature portion, which your mother will be signing the bond, acknowledging that if you violate, she's the one who's the heat's going to come down on. Do you understand that?
Yes, ma'am.
Do you understand she could lose her home?
I would never do anything to jeopardize that.
Okay. All right. So conditions will be absolute sobriety, no alcohol, no illegal substances, no paraphernalia, no prescriptions without a valid prescription. Other than for work-related purposes or seeking work, you may not be in any establishment that has the primary purpose for the sale or the service of alcohol, such as bars, taverns, liquor stores, beer tents, etc., including the casino. You're subject. Go ahead.
I 86 myself from the casino a year and a half ago. So am I allowed to go in there to reapply and to try and lift my 86?
You could do that for job-related purposes only.
Yes, ma'am.
I am ordering you to random, not subject to, I'm ordering you to random testing of your blood, breath, and urine by the court's justice coordinator, Tessa Anderson. And that is a cost to you. And that would be $25 a pop. Do you understand that?
Yes, ma'am.
And again, you must pay that at the time of testing. Do you understand that?
Yes, ma'am.
And the court is doing that because I am taking a significant risk with the Class D felony and the allegations in that complaint. But I'm hoping to
can't-
give you another chance right now.
I appreciate this very much, Your Honor. And I thank
If
you
you
for
if you test positive for any substance, your bail's revoked. Do you understand that?
Yes, ma'am.
And that includes alcohol. Do you understand that?
Yes, ma'am.
All right.
Absolute sobriety.
You may not be around anyone without the court's permission who has a felony conviction. They're either on probation or extended supervision, or they have been convicted of possession with intent charges. Again, without the court's permission. Do you understand that?
I understand.
Obviously, if you're at a bar and you're serving drinks, that's fine, but you may not have any communication other than, here you go, buddy, $4. Okay?
Correct.
All right. Any other conditions the state would like to see?
Your Honor, I would also request that any known drug dealer houses or properties that he stay away from those as well, please.
All right, that will be added as well. Anything further, Mr. Vila?
No, Your Honor.
All right. So the court will amend bond with the lower cash and with those conditions before it takes effect and before you can be released. The money needs to be paid. You need to have signed the bond and your mom needs to sign the bond, okay?
Yes, ma'am.
All right. Now, we need another, we already have the date. We're all good to go. Anything else?
Nothing further. Thank you.
Thank you. Then we are adjourned.
Thank you, Your Honor.
So you would need to wait. I don't know. It's going to take her a little bit to get the bond done and then you can come sign it, okay? Who is in the county jail? Is this Mr. Tolgren? All right, Mr. Tolgren, can you hear me?
Yes, I can.
Thank you. We will go on the record in the matter 23 CM 161, State of Wisconsin versus Ryan Tolgren. The state appears through District Attorney Kevin Schmidt in person. We have Mr. Joel Feliski in person. We have Mr. Tolgren by video conferencing in custody in Burnett County Jail. We're set today in this matter for a plea and sentencing. The court had issued a warrant for a failure to appear. Mr. Tolgren was picked up on that warrant. However, the parties have reached an agreement. Mr. Feliski, do you have documents for me?
I do, Your Honor. I'll recite on the record here that Mr. Tolgren has agreed to plead to counts 1 and 3 in the complaint for 23 CM 161. The remaining counts are going to be dismissed and read in. The parties are making a joint recommendation for, on both count 1 and count 3, a $500 fine inclusive of costs to total $1,000. I have a completed plea questionnaire with me. May I approach?
May. Thank you. Do you want your clip back? Mr. Tolgren, I have in front of me a plea questionnaire waiver of rights form, as well as a document that has the elements for these offenses. And it appears that your signature is on both of these documents or your initials. Is that correct?
Correct.
You actually sign RT. Is that correct?
Correct.
And you heard the agreement that was reached and that was stated on the record?
Yes, I did.
You are pleading guilty to 2 misdemeanors. You're 45 years old. You have 12 years of schooling. You can read, write, and you understand the English language. Is that all correct?
Correct.
Did your attorney thoroughly go over these documents with you?
Yes, he did.
Did he essentially read them to you word for word
Yes, he did.
and you understood everything completely?
I did.
You understand that if you, because you you allegedly committed crimes, you are entitled to constitutional rights, and each of those rights is listed on this document. Did your attorney thoroughly go over those rights with you?
Yes, he did.
Do you understand them completely?
Understand him completely.
And do you understand that by pleading guilty, you're waiving and giving up these rights?
Yes, I do.
Do I need to go over these rights with you in any more detail?
No, you do not.
You understand that if you're not a citizen of the United States, your plea could result in your deportation.
Yes,
You understand the state would have to prove as to count 1, misdemeanor bail jumping as a repeater,
Yes, Your Honor.
repeater that in Burnett County, Wisconsin, having been charged with a misdemeanor in Polk County case number 23 CM75 and having been released from custody, you intentionally failed to comply with the terms of your bond by operating a vehicle without an ignition interlock device. Do you understand what the state would need to prove?
yes, I do.
Do you understand that upon conviction, you could face a fine of up to $10,000 or imprisonment of up to 9 months or both? But because there's a repeater, that means the maximum term of imprisonment for this underlying crime, because it is a misdemeanor in Polk County case 20 CF39, and it has not been reversed, that the maximum term of imprisonment may be increased to not more than 2 years. Do you understand that maximum penalty?
Yes, I do.
And you understand that as to count 3, operating a motor vehicle while revoked as a repeater, do you understand the state would have to prove that on the same date and time in Burnett County, Wisconsin, you were a person whose operating privileges have been revoked. However, you operated a motor vehicle on a highway during this revocation period. Do you understand what the state would have to prove?
Yes, I do understand.
Do you understand the maximum possible penalty for the underlying misdemeanor could be a fine of up to $2,500 or imprisonment for not more than 1 year in the county jail? But because you were convicted in that Polk County case and that was unreversed and you're pleading as a pleader or as a repeater, the maximum possible penalty could be increased to not more than 2 years. Do you understand what that means?
Yes, I do understand.
You understand that there's a recommendation to the court for costs only for both of those counts, but do you understand I don't have to follow that?
Correct.
Said differently, I could sentence you to the maximum possible penalties if I thought it was warranted. Do you understand that?
I do understand.
Do you still wish to proceed and enter a guilty plea?
I do.
You are pleading guilty by video conferencing. Do you understand you have the right to be here in person
Correct.
and you're waiving that right?
I'm waiving that right.
All right, thank you. If you have questions or concerns and you need to speak with your attorney, let me know. I'll send them to our Zoom room and give you a confidential session, okay?
Okay.
Did your attorney go over the facts of this case with you that are alleged in that criminal complaint?
He did.
And do you understand those facts as they're alleged completely?
Yes, I do completely.
And I'm not going to have you say that each of those allegations is 100% accurate and true. But for the most part, as to the crimes you were pleading guilty to, are those facts accurate?
They are accurate.
Mr. Feliski, may the court use the probable cause section of the criminal complaint to find a factual basis?
So stipulated.
Has anyone made any threats or any promises to you, Mr. Tolgren, for you to plead guilty to the charge?
No.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes.
and voluntarily.
Voluntarily.
Are you satisfied with your attorney's services?
I am.
Any questions for the court or your attorney before I proceed?
No.
As to count 1, misdemeanor bail jumping as a repeater, how do you wish to plead?
Guilty.
As to count 3, operating while revoked as a repeater, how do you wish to plead?
Guilty.
Court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of those counts. The remaining counts will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. I know he has jail credit from being picked up on the warrant, but does he have other jail credit in this case?
Your Honor, I believe it's just the 7 days from when he was picked up on the warrant.
All right. Argument and recommendation, Mr. Schmidt.
One sec.
Well, he was in custody in July for a warrant as well.
Oh, I see. Believe that, is that Polk, Your Honor?
Nope, in mine.
Oh.
I had a warrant and I believe. Oh, yep, I had a warrant. A bench warrant. He failed to appear December 13th, 2023. And then he appeared in custody July 23rd, 2025. I'm not seeing when the warrant was served upon him. Oh, warrant was served.
Judge, I think the credit's right, because you have to remember he has cases in Polk that recently concluded, and he has cases still open in St. Croix County.
All right, so you think only the 7 days, even though he sat sometime here in 2023?
That's what my belief is. He kind of accrued a lot of cases, so it'll be unclear where the credit lands on all those cases.
Oh, okay. All right. Argument?
I think this is appropriate here, given what the severity of these offenses are. I think that the main driving force for resolving this case in the fashion we did is to end a 2023 case that is not on the high severity level. I don't think I need to say much more than that on this one. Thank you.
Mr. Felisky?
I'll keep it very brief, Your Honor. Discussing this case with Mr. Tolgren, it seems that he was in custody, as the state had mentioned, on various other cases, more or less since this case was initiated in 2023. I understand he was in Polk for some time. St. Croix, I believe he may have sat a prison sentence, if I'm not incorrect. He sat a significant amount of time on this case. I think costs are appropriate as a deterrent. I think this is ultimately an appropriate agreement, and I would ask the court to follow it. Thank you.
All right. Mr. Tolgren, do you care to make any statement today? Let me know anything.
I do not.
Are you on 1408 Highway 64?
I am not. I no longer live there.
Do you have an address where you're going to reside?
I do not have an address, but for the most part, the shelter down the road.
Okay. Are you going to get a job?
Yes, I am.
How
I
do
do.
you expect to pay the money back?
I do have, a check, get back on my SSI for the most part. So I can work part-time.
Okay. So once you get your SSI started again and you're working part-time, you're going to be able to make payments and get this paid off?
Correct.
Do you understand that if I don't get a payment, I will issue a warrant and you could sit up to 6 months in jail?
Yes,
So it's very important you make your payment. Do you understand that?
I do.
Anything else you want me to know?
No, Your Honor.
All right. He has bigger fish to fry in other counties, and the underlying crimes here were operating with while revoked, not having that ignition interlock device, in the possession of THC and paraphernalia. And then he got the higher charges of the misdemeanor bail jumps from the other open cases, in Polk County. So it has sat some time on this case, and he indicates that he's going to make his payments if the court does costs, and he understands the ramifications if he does not. Based upon that, he can deal with what he needs to deal with in the other counties. The court is going to order 9 days of jail per count, concurrent with each other. So he has 7 days of jail credit. So that is a time served. I'm going to order the $500 per count, and that will be payments of $100 per month. First payment will be due in November. Okay, I'll give you a little bit of a break. before you have to start paying, but first payment in November. When you are released from custody and you have a place where you're residing, you must contact Mr. Feliski and the court to notify them of a mailing address, okay?
Correct. Yes, Your Honor.
And do you have is your telephone number, does it still end in 4864 or don't you have one?
I don't have one at the moment.
You must also update your telephone number. I'm going to tell you, Mr. Tolgren, if you fail to make even the first payment, I will issue a warrant. You see what happens when I issue a warrant. You sit in jail until I'm able to hear from you. Do you understand?
I do understand.
All right. So again, $500 per count. He will update the court, an address and telephone when he is released and has that ability, has those services. 20 days to appeal. Should you fail to appeal within 20 days, you lose that right. Ordering your DNA, you must provide your DNA. The jail will take that. You can request it be expunged from the system through a written letter to the Department of Justice. You fail to pay your fines and fees, the court will enter a civil judgment and will issue a warrant and will have a contempt hearing to see if you are in contempt and if there's any sanctions that need to be assessed at that time. What am I missing, Mr. Schmidt?
Nothing from me.
Mr. Feliski?
Nothing further. Thank you.
All right. So good luck to you, Mr. Tolgren. Hopefully you can get out and find some stability and get your other matters resolved.
Yes, Your Honor. Thank you.
I have Mr. Doryat in custody. I cannot see you, Mr. Doryat. Are you representing Mr. Doryat?
I'm making a special appearance, Your Honor.
Have you went over the criminal complaint with him?
I did not, Your Honor. There is some information I can update the court with at this time. He did apply with our office. He is eligible. However, upon review by our staff, there is a conflict at issue, so we are still working on assigning counsel to him.
All right. Mr. Doryat, I can kill two birds with one stone. I can hear your bond modification. And if you want to, we can go over the criminal complaint and have your first appearance and then set the matter further out to allow you to get an attorney.
Okay. Yeah, that'd be awesome. I actually do have an attorney. He's been my attorney my whole life. His name's Thomas Mulligan or Thomas Jr. Mulligan, from Shell Lake. He would probably have it set out farther. I finally got to reach out to him today, but I was a little late. I was hoping for a bond modification on which I could either get a signature
And
bond.
we're not on the record yet. So I understand all that. It's all good to hear. And I'm not sure if Mr. Mulligan takes public defender cases, but if he does, maybe the public defender will even appoint him to you for that. But we'll just go through your initial appearance and we'll get you down the road. Okay.
Okay, awesome.
We will go on the record in the matter 25 CM 171, State of Wisconsin versus Josh Doryat. The state appears through Assistant District Attorney Jose Vila in person. We have Joel Feliski making a special appearance on Mr. Doryat's behalf here today. We have Mr. Doryat appearing by video conferencing in custody in Burnett County Jail. We're set today in this matter for a bond modification hearing. Off the record, the court went over the initial appearance and what that entailed, and that we could kill two birds with one stone and have the initial appearance here today, and then get the matter moved out down the road. Mr. Doryat is looking at having a public defender or seeking his own private attorney. Mr. Doryat, you wish to proceed with this first hearing, the initial appearance, is that correct?
Yes, I do.
And then the court will hear a bond modification request from you, and you'll be able to tell me what you want to tell me. Mr. Feliski can tell me anything he would like to tell me. Off the record, Mr. Feliski, you indicated that he does qualify for public defender, but there's a conflict with your internal office. Is that correct?
That is correct.
So you would be seeking outside private counsel to take a public defender case, correct?
That is correct.
All right. And so we have the criminal complaint in front of us, and it looks like, do you have that criminal complaint, Mr. Doryat?
Yes, I do.
And so were you able to read that thoroughly?
So I read through it. Basically,
I don't want you to don't tell me anything about like the facts of the case, because anything you say right now can be used against you. I would say just wait, talk to your attorney. This is just going over to make sure you understand what's being alleged.
Yep, I do.
Okay. And so count 1 is criminal trespass. It alleges on or around September 11th, 2025 in Burnett County, Wisconsin, you intentionally entered and remained in the dwelling of DD without the consent of the owner of the property. That includes the dwelling, as no person was lawfully upon the premises under circumstances that tended to provoke a breach of peace. Do you understand that allegation? And do you simply just understand what's being alleged?
Yes, I do.
The maximum possible penalty upon conviction could be a fine of up to $10,000 or imprisonment of up to 9 months or both. And you understand that?
Yes, I do.
And do you need me to read anything else for you out loud, or do you understand all that's in that criminal complaint?
I understand everything in that criminal complaint.
All right. And you wish to enter a not guilty plea, is that correct?
I wish to enter, could I do,
Mr. Doryat, I'm going to advise you, making a special appearance on your behalf. Again, please do not say anything regarding the facts of your case at this time. You do not have an attorney to represent you. I'm going to strongly advise you to plead not guilty at this time.
And if you plead not guilty and it's going to be down the road, and then again, you can at a later time through an attorney appointed can tell me any of those things that you want to tell me, okay?
Okay. Yeah, I'll do not guilty.
So not guilty will be entered on your behalf. You are entitled to a jury trial. You would be entitled to a speedy trial should you request one. We're going to set this matter sometime down the road to allow the public defender's office to appoint somebody for you. Hopefully they can do that in a quick fashion. How about Monday, October 27th at 11:30? So Monday, October 27th at 11:30, we're going to set the matter. Bond modification argument. Does Mr. Allen wish to present information, or Mr. Doryat to me? He's able to do that himself if he wishes.
I would advise him to do so with, again, and I just want to stress this because it is very important that you understand, sir. Please do not get into any of the facts regarding your case for the purposes of bond. You may speak to residency, links to the community, your ability or inability to pay, so on and so forth. But again, be very certain not to discuss the details of what the complaint is alleging. Okay.
Okay. All right. So
Tell me about yourself.
Okay, so I do have a side business, kind of. It's not like a full business, like side jobs. So I can do a payment plan. I can do, so I do side work. I do like shelving, small construction. Obviously I wouldn't be able to do big construction. I don't have a crew or nothing like that.
Mr. Doherty, I'm just going to stop you right there. How long have you lived in Wisconsin?
So I lived in Minnesota only. I lived in Wisconsin my whole life. I lived there for about 2.5, 3 years.
Okay. And so right now you're living in Spooner, right? Or you have a Spooner address? And that's where you're going to reside, in that area?
Yep.
And is it on Elm Street, or is that the house of issue?
So Elm Street isn't the house of issue. The house was on Main Street in Webster, and that's Burnett County.
And so you are, well, we have Spooner addresses in Wisconsin too, and Shell Lake and Cumberland, I think. We have a lot. And Frederick. So you would be residing at that Elm Street address?
I'd be residing at the 519 South Front Street in Spooner, Wisconsin.
Okay.
I do have another address.
South Front Street. All right. And so is your telephone number, does it end in 7477?
No, it doesn't. It is
All right. And may we send you text message notifications?
Yes, you can.
All right. Okay. Forgot whose case this was. Mr. Vila?
Your Honor, Mr. Doryat does have a decent amount of criminal history in Wisconsin. Granted, a majority of it seems to be lower level misdemeanor offenses. This offense at hand is a lower level misdemeanor. The state would not be opposed to modifying bond to a signature. However, we would request that a no contact be included to include the victim, in this case, DD, in addition to her residence, which is already listed on the bond.
All right. Here's what I'm going to do, Mr. Doryat. I want you to get out. I want you to get stable. I want you to find a job. So I am willing to modify it from the $250 cash to just a signature bond. But it does have those conditions of absolute sobriety and random testing of your breath or urine. And no contact at that Main Street Webster address, and no contact with DD. Okay.
Thank you, Melissa.
What?
Thank you, Melissa.
What's my name? Who am I?
Judge Melissa.
Okay, I'll go with Judge Melissa, but not just
Judge
Melissa.
Morgan.
Okay.
Okay.
I earned the black robe.
All right. Sorry.
All right. Okay. So then you'll be released on signature bond with those conditions. So go get a job, do all the things, and then come back to that court date. Okay.
No.
Do you have transportation?
I do. I do have my aunt and my uncle. They brought me up to Webster here, so they can pick me
All right.
up.
If you're having a problem finding transportation, I would approve you to appear by Zoom if you know how to do that, or telephone. Okay.
Okay.
So just keep your attorney, whoever that's going to be, updated on your ability to get here in person, or you can call my assistant or the clerk. Okay.
Okay.
All right. Thank you. We'll see you October 27th.
All right, Ms. Griffin, why don't we start with you over at the county jail? You're still muted over there.
I apologize for that, Your Honor. Good afternoon. I'm here with Mr. George Flores. He is matter number 3 on the calendar today.
Okay. And Mr. Flores, you're here today for a preliminary hearing on an allegation of domestic violence that the state alleges occurred on September 18th. Go ahead, Ms. Griffin.
Thank you, Your Honor. He has been advised of his rights, and I do believe he understands them. I did send Madam Clerk updated contact information, including a phone number, so text message reminders would be helpful to Mr. Flores. We are requesting that Thurston County Public Defense be appointed to Mr. Flores. He does receive Social Security, is therefore statutorily indigent. He is also ex-military. He receives about $1,400 in total from his retirement pension and his veteran's disability. So again, statutorily indigent, but his income is still at the lower end that we see when we request public defense. So I do believe he qualifies on both fronts. And I would be contesting probable cause today, and specifically I would request that the state at this time establish probable cause for both charges of assault for as well as unlawful aiming.
All right, Mr. Flores, I will appoint the public defender for you. I've reviewed the declaration for probable cause, and I do find probable cause for the crime of unlawful display of a firearm, 9.41.270.
Your Honor, it's my understanding that unlawful display is not what's being charged. It's unlawful aiming as well as an assault for charge.
Ms. Griffin, nothing's been charged yet.
This is the information that's been confirmed from DPA Fortunato at this time, so that's the information that I'm going off of.
But let's look at it systematically. It's probable cause determination. No crime is charged. If there is probable cause for any crime, the state has a basis to set release conditions. Based on the declaration filed, I do find probable cause for the crime that I indicated. And with that finding, I'm going to ask the state what's their recommendation on release conditions.
Invalid. In Your Honor, Isaac Fortunato on behalf of the state in this case. There's no objection to a PR release. We are going to be asking for the standard domestic violence conditions that include no criminal law violations, no firearms or dangerous weapons. I will also be asking for a no contact order protecting the alleged victim here, Miss Barbara Flores. I have noted that a civil standby should be authorized. The reason I'm asking, I'm also asking for a DCR evaluation prior to release from custody. The report here indicates several statements of concern from Mr. Flores, which include you want to see a psycho, and also it would be a good day to die. For that, in combination with the allegations present here, I do think that it's important to determine if Mr. Flores is an immediate risk to himself and the community before he's released from custody. I do believe Ms. Flores is present either in the courtroom or over the Zoom call. She did indicate to our office that she did wish to speak with regard to conditions of release for Mr. Flores as well.
Okay. All right, is Barbara Flores here?
Yes.
Okay, and Miss Flores,
Yes,
what would
I'm
you like
here.
to tell me?
I just want to say that the gun was never pointed at me. My husband never threatened at any time to hurt me at all. Never did.
All right, thank you, ma'am.
The gun was always held up.
Ms. Griffin, your recommendation on release?
Your Honor, I would echo what Ms. Flores has shared with the court in support of objecting to the no contact order at this time. I do think the condition of no firearms or deadly weapons would be sufficient to mitigate any of the state's safety concerns. Mr. Flores has absolutely no criminal history. It sounds like this was an isolated incident that was in large part influenced by as you read in the probable cause statement, potentially influenced by Mr. Flores struggling with being retired and maybe experiencing some hardship with that. It doesn't sound like Ms. Flores feels scared of Mr. Flores. I think that it would be the best for both of them if Mr. Flores could return to the home, again, with no firearms and no deadly weapons being present in the home. And I would also echo what Ms. Flores has shared with the court with regard to the firearm not being pointed at Ms. Flores at any time. The police report indicates that there was a handling of a firearm, but again, at no point and at multiple points in the probable cause statement, Ms. Flores makes it clear, and it is clear from the report that the firearm was never pointed at Ms. Flores, and it was also unloaded for the entirety of the alleged incident. So again, based on that, I would strongly object to a no contact order at this time.
All right, so Mr. Flores, I will release you today on your own recognizance. There are some conditions attached to your release. Those conditions will be: don't violate the law, don't possess any firearms or dangerous weapons. And I am going to issue the no contact order that prohibits any contact with Mrs. Flores until further order of the court. I think that the probable cause statement does establish a danger to Ms. Flores and that she does need the protection of a no contact order. That situation with the display of the firearm is alarming and warrants alarm for the safety of others. In fact, it's one of the elements of the crime. There are two other stipulations to your release here. One is that the designated crisis responder is authorized to come and interview you. If they believe it's appropriate to petition for a civil detention, they can do that, and you could be briefly detained for that purpose. And two, Mr. Fortunato, this may require some follow-up with corrections officials on your part, but Mr. Flores is not to be released until the firearm surrender order is complied with.
Understood. I can talk with corrections. Thank you.
And Mr. Flores, your next court date in this case will be on Wednesday, September 24th at 9 o'clock.
They'll print out the date for you, so don't worry about it.
And Ms. Griffin, release conditions can be reviewed at that hearing.
Understood. Thank you, Your Honor.
Can I say something?
Your Honor, the individuals in the courtroom have advised that law enforcement did take the gun at the scene.
All right, but I'll also need proof of compliance with the surrender order. I appreciate you telling me that, but yeah, it's gonna, there's a way that has to be complied with. There's a process, and it's written down on this order that he's gonna get. Okay. Okay. All right. Thank you, Mr. Flores. We'll see you next week.
Thank you, Your Honor.
And we had an individual there at the Nisqually. Oh, here he comes. All right, sir, over at the Nisqually jail. What's your name, please?
Jonathan Layton.
All right, Mr. Layton, you're here for a warrant hearing. It looks like you had failed to appear to this court for a sentencing hearing on your DUI case. That was some time ago.
Yeah, I would like to talk to an attorney. I turned myself in. I just want the court to know that I did turn myself into. And
yep, we'll get an attorney on that. Have you talked to an attorney yet today?
No.
And Your Honor, I can provide some insight to this. This was listed on my end as a sentencing hearing. Rather confusing that we were just reset for the sentencing hearing.
Yeah, it's
I
not,
was
though.
under the impression it was going to be another attorney's actual sentencing hearing. I understand now where we are at. So I did not have the time to speak with Mr. Layton. Our request anyways would just be to reset this, understanding where we're at and looking at substantial outcome that could come from this case.
All right, do you want a sentencing hearing next week then?
I think that would be appropriate, just so that time we have an attorney who is able to go over everything with Mr. Layton. He can talk, ask all the questions he needs.
Tuesday?
I think that would be fine.
Okay.
Am I going to be in custody?
What's that now?
Am I going to be, because I turned myself in and I have these.
Yeah. No, yes, you're going to be held in custody to answer your question. All right, so Mr. Layton, your sentencing hearing will be reset to Tuesday, September 23rd at 1:30. And I've assigned the public defender back to your case, and they'll visit you before your sentencing hearing.
Okay.
All right, see you next week, sir.
Thank you.
Okay, Ms. Griffin, back over to you.
Your Honor, I'm here with Mr. Dylan Odell. He is matter number 11 on the calendar. We're here for a warrant return hearing. He was not present at a confirmation hearing on August 13th. I believe Mr. Odell, sorry, would you like me to give you a minute?
Oh, that's fine, go right ahead.
He was not present at a confirmation hearing August 13th of 2025. Mr. Odell relayed to me that the paper that he had a different court date on it, and I believe he received communication from his lawyer that he didn't have court until October, so I think it was just very unclear what his obligations were. He has recently been in contact with his attorney, Mr. White. I've confirmed a good address and a phone number with him and sent that to Madam Clerk. He has not previously been a recipient of text message reminders, so I do think that that would be very helpful to Mr. Odell at this time, and he also lives locally, so I do think that it's reasonable to quash this warrant, reset that date, and release Mr. Odell from custody today.
Okay, Mr. Lindgren?
Well, Your Honor, Mr. Odell does have, it looks like, 2 active warrants, one in Lakewood, one in Lewis County. However, this is his first FTA in this case, and he turned himself back in pretty quickly. And so the state doesn't object to PR release today, but he should get those warrants figured out, and future FTAs will probably draw a bail request.
Okay, Mr. Layton, I will release you. Or, I'm sorry, Mr. Odell. I was looking at somebody else's file. All right, and get you back on the calendar here. Let's get a pretrial hearing for him, Amy. Your court date will be October 24th at 10:30. And you also need to go and address your warrants in Lakewood and in Lewis County.
Yes, Your Honor.
Okay, we'll see you next month.
Thank you.
Thank you.
And then, sir, over at the Nisqually Jail, your name, please.
Michael Weeks.
Okay, Mr. Weeks. Good afternoon, sir. All right, and Mr. Weeks, today you're in court for your first appearance in your arraignment on a charge of theft in the third degree that the city of Tumwater alleges occurred on September 18th. Is that going to be your case, Ms. Myers? Mr. Weeks?
Yes, Your Honor.
Okay, go right ahead.
Thank you. I did have time to speak with Mr. Weeks before court today. At this point in time, we'd be entering a plea of not guilty. We are not contesting probable cause for the purposes of today's hearing, and we waive any formal reading. I do believe he understands his rights as I've explained them to him. At this point, we would be asking that Thurston County Public Defense be appointed. He is statutorily eligible as he receives Social Security.
Okay. All right, Mr. Weeks, I will appoint the public defender to represent you and enter your not guilty plea to the theft charge.
Okay, thank you.
And then, Mr. Lindgren, what's the city's position on conditions?
City recommends PR release with no new law violations and stay away from Walmart.
Walmart, any objection to that, Ms. Myers?
No, Your Honor.
All right, Mr. Weeks, then you're going to be released on this case while the case is pending. Don't violate the law and don't have any contact with Walmart.
Okay.
And I will give you a date to come back to court for your pretrial hearing.
Okay. Thank you.
Okay, that date will be on October 29th at 9 o'clock.
Okay.
All right, you'll get that in writing before they release you from the jail. Okay, Mr. Weeks, you're good to go.
Yeah, thank you.
Ms. Griffin, back over to you.
Your Honor, I'm here with Mr. Junior Haritch. He's matter number 8 on the calendar this afternoon. He is also here for a warrant return.
Yes. Okay. All right. So he is on an SOC with the state. When he wasn't here for the final hearing in his case back in April, the state also moved to revoke based on a lack of compliance with the conditions of the SOC. So what's the state's current position on the warrant?
Well, Your Honor, this isn't his Mr. Haritch's only warrant. He's got another active warrant in King County Superior, another one in Puyallup Municipal, and so the state is asking for $5,000 bail.
Ms. Griffin?
Your Honor, Mr. Haritch is currently homeless. His warrants are the result of him both not having a phone to be able to join on Zoom, as well as not having reliable transportation. He usually resides in the Kent area, so not exactly convenient in terms of coming to Thurston County. However, he recently did get a phone. He was going to call the court to schedule a hearing, but unfortunately was arrested and brought here before he was able to do that. He is aware of his active warrants. We discussed those. And again, now that he has a phone, he has more resources and more opportunity to get in contact with those courts. I would strongly object to any kind of bail request at this time. Again, given that he is homeless and does not have the financial means to post that, that would be a no bail hold for Mr. Haritch given his financial circumstances. I would like for Mr. Haritch to be released on his personal recognizance and set this for a future date.
All right, and then what about the fact that he got convicted in Kent Municipal Court of violating a protection order last month after he failed to appear for his hearing in this case? Does that change the analysis?
Are you asking me, Your Honor?
Well, I guess I'm asking you if you're willing to answer.
I do see that there was a protection order violation
I'll get that. I'll get
out of Kent Municipal. I would still maintain that if the concern is that Mr. Haritch is not going to make his court dates and be in contact with the court and meeting his obligations, I think that he's been experiencing some hardship lately with being homeless and not having financial resources or a phone. And now that it seems like he has a phone, he's able to be more in contact with the court and hopefully abide by those obligations. So I would like to give him the opportunity to do that.
And I think the state's request for bail here is reasonable under the circumstances of the two other outstanding warrants and the conviction that occurred after he failed to appear in this case. So $5,000 is reasonable. That's what I'll set. And we'll set a violation hearing on the SOC. So that needs to be on Thursday. Okay. All right. The hearing will be on October 2nd at 10:30.
Thank you, Your Honor.
And I'll also reappoint the Public Defender's Office for Mr. Haritch.
Thank you.
Okay, and now we'll go back out to Nisqually at Nisqually Jail. What's your name, sir?
Rex Nelson, Your Honor.
Okay, thank you, Mr. Nelson. All right, and Mr. Nelson, you're here in court today because you failed to appear for a confirmation hearing for your Lacey theft case back in April. So we're going to decide today whether you're going to need to post bail or whether you can be released. All right, Mr. Swenson.
Your Honor, Mr. Nelson's actually prepared to resolve his case today. I reviewed statement of defendant on plea of guilty with him, and the court should have that guilty plea in its file.
Yes, I do have that now. Okay. All right. So, Mr. Nelson, did you want to just plead guilty to the theft charge instead?
Yes, Your Honor.
All right. Did you review your guilty plea statement with Mr. Swenson?
Yes, Your Honor.
Now, you're waiving your rights in this case by pleading guilty to theft. So you give up the right to go to trial in this case and have the prosecutor prove the charge beyond a reasonable doubt to a jury. The right to call your own witnesses to court to testify in your defense, the right to hear and question the witnesses who would testify against you. You're giving up the presumption of innocence and the right to appeal your conviction. The maximum sentence you can get is 364 days in jail and a $5,000 fine. And even though there's a sentence recommendation written on your guilty plea form, you need to understand I'm not required to do that and could impose up to the maximum sentence. Mr. Nelson, did anybody make any threats or any promises to you to get you to plead guilty to theft?
No, Your Honor.
And the statement written on your plea form says on October 27th of 2024 in Lacey, I took property of Target and intentionally left the store without paying for it. Is that your statement?
Yes, Your Honor.
All right, I will accept your guilty plea then. Okay, Mr. Sharp, can I hear from the city first?
Thank you, Your Honor. The city would ask that the court adopt the recommendation. It's agreed between the parties.
Okay. All right, Mr. Swenson.
That's right, Your Honor. This is an agreed recommendation. I'd also ask the court to follow it. Mr. Nelson is accepting responsibility today. He recently resolved his 2 Olympia cases. He's been in custody for the last 3 weeks or so. Once he's released on this, he should be released. He has somewhere to stay. He'll be staying with his grandmother. Sounds like he has a plan to move forward, and this will be the last of his cases to resolve, Your Honor. So hopefully, I don't think there's going to be any issues moving forward.
All right, Mr. Nelson, would you like to say anything before I sentence you?
No, Your Honor.
Okay. Well, it sounds reasonable and fair to me. I appreciate you doing this. And I know you've been in jail for longer than just what this case says. So I'll accept the recommendation and impose 364 days, 362 days suspended, credit for 2 days already served. So you're eligible to be released. For the next 2 years, don't violate the law, don't go to Target, and there'll be no financial obligations.
Thank you, Your Honor.
Okay, good luck to you, Mr. Nelson. Okay, Ms. Griffin, we'll go back over to you.
Your Honor, I'm here with Ms. Bridget Gonzalez. She's also here for a warrant return. Looks like she was not present at a pretrial back in May of 2022. I do believe that she was told at arraignment that they would send her notice of the next court date. She didn't receive it. I think that barring that lack of information, she had just went about her life. She is also currently aware of her active warrants in both Lewis County, or just the one active warrant in Lewis County District Court. She did call and schedule a warrant quash hearing, but then she was involved in a car accident, so she didn't attend, but I still would like it noted that she made that effort to get it quashed, and now that she's since recovered from that car accident, I do believe that she will call again and reschedule. I did send updated contact information, including an address and a phone number to Madam Clerk for Ms. Gonzalez, so that will help her get those court dates in the future. And I will point out to the court that it looks to me as if she's had no new law violations since then. I can double check that now, but that was my initial impression this morning.
Yeah, that's correct. Okay, it does look like her pretrial release conditions will have to be changed to reflect the required ignition interlock device. I also see that there's a COVID era release order, and you are correct, it does not contain a court date because in those days we were sending court dates, and so it's possible that we sent one and she didn't get it. Okay, then Mr. Lindgren, what's the state's position on release here?
Well, Your Honor, the state is concerned that this is a 2021 DUI case that never even made it to its first trial confirmation before it went on warrant status, acknowledging the circumstances of COVID-19. The other warrant she has been out even longer than this one. And so the state is concerned about Ms. Gonzalez's willingness to appear. And so we're asking for $5,000 bail. And Your Honor is correct that the IID requirement will need to be imposed.
All right. Ms. Gonzalez, I'm going to give you the benefit of the doubt and the explanation that you offered for why you weren't in court. You're not the only person who, in those days, didn't end up getting notices because of the changes that we made to deal with COVID and to deal with people not being in court to get their court dates. So that and the fact that it doesn't look like there's been any trouble since, I'm going to release you on your personal recognizance. So the one thing I do have to tell you, though, is you are required, if you drive a vehicle, to have it equipped with an ignition interlock device. That's I'm going to add that to your release conditions. All right. And today we will give you your next court date.
And Your Honor, we would also request for Thurston County Public Defense to be reappointed to Ms. Gonzalez. She does receive food stamps and qualifies.
Yes, we'll also reappoint the public defender. Okay, so October 29th at 9 o'clock, and that will be written down on the order that you get when you're released from the jail.
Thank you, Your Honor. And I do believe that Ms. Gonzalez has a question.
Sure.
I pleaded not guilty the first time, but I'm sticking to it because I'm trying to fight it. So then the interlock shouldn't have to be put on until we get done with all that?
Well, there's a rule in the law that if you have a prior offense and you get released, like you're being now on a subsequent offense, you have to have an ignition interlock device. But even though your prior's clear back in the 90s, it still counts for purposes of having an ignition interlock device.
Okay.
Okay, so we're going to switch back over to the jail. Ma'am, over at the Nisqually Jail, can you tell us your name, please? Over at Nisqually Jail, can you tell us your name, please?
Is that how you say last name? Bowling.
The judge is talking to you.
Oh.
Yeah, ma'am, can you tell us your name, please?
I'm Sarah Bowling.
Okay, thank you. All right, and Ms. Bowling, you're here today in court for your arraignment for a charge of assault in the 4th degree that the city of Tumwater alleges happened today. Okay, Ms. Myers?
Your Honor, she is partially deaf, so you might need to speak up.
That won't work.
Okay.
That's a microphone. She won't hear my voice. She'll hear the microphone. And if she needs a hearing assistance device, we can do that.
Do you think she would need one?
Possibly, she does wear hearing aids.
We'll try and then we'll see.
See what happens.
Your Honor, I did have time to speak with Ms. Bowling today. I read her rights. I do believe she understands them as I explained them to her. We waive any formal reading. At this point in time, we're going to enter a plea of not guilty, and for today's purposes only, we're not contesting probable cause. I would ask that Thurston County Public Defense be appointed. She is a caregiver for her mother, and the income she has is through the state caregiver benefits, and she receives about $2,000 a month. By the end of it, she has about $500 left.
Okay. All right, and Ms. Bowling, I'm going to appoint the public defender for you and enter your not guilty plea. And what's the city's position on conditions?
City's position, Your Honor, city recommends PR release with conditions of no new law violations, no firearms or dangerous weapons, an NCO protecting the victim in this case, which I believe would come with a civil standby. Thank you. And a DCR evaluation prior to any release.
Okay. So that person is listed as Jean Bowling with a 1949 birth date. Is that her mother?
Yes.
Yes.
Okay. Ms. Myers, I guess I'll hear from you.
I'm sorry, Your Honor. I missed what Mr. Lindgren said.
He wanted a personal recognizance release, but he also wants a no contact order with Jean Bowling.
Your Honor, we would contest any no contact order at this time. The incident arose out of a mental crisis. This was a situation that police were called, I believe, to get care and help for Miss Bowling, and because of this, it ended up in her arrest.
I need to ask you a question. Do you mean a mental health situation with the defendant, Ms. Bowling, or with her mother?
Oh no, I'm getting my Miss Bowling's confused. Back it up one moment.
Okay.
While I'm trying to get them straight, we would also still contest them because she is the caregiver for her mother. I believe she is the primary caregiver for her mother. She lives with her. She is the one who she's getting state funded for taking care of her. I think that should this not be put in place, or should this be put in place, not only would this put her as a disadvantage financially, who knows what could happen to her mother medically, because she is the one who's responsible for taking care of her.
And Your Honor, the mental health episode referenced in this case does stem from the defendant.
Yes. It was
from hers.
Yes, Miss Bowling. Sarah Bowling, not Jean Bowling.
Yeah, thanks for the clarification. Okay, so difficult situation. Do you know if anybody else lives in the residence with the Bowlings?
Your Honor, I think we have somebody in the courtroom who would be able to explain it a lot better.
Have a seat right there. Yep, see
You
that
can
right
sit
there? See that lighted microphone on the table?
Yes, yes, Your
Okay,
Honor.
that'll let us all hear you.
Thank you, Your
All of
Honor.
us will hear you. So what's your name?
My name is Hannah Hart.
Okay, and how are you related to all this?
Sarah Bowling is my niece and Jean Bowling is my grandmother.
Gotcha. Okay. All right. So what do you want me to know about the situation?
So Jean Bowling, my grandma, has had a series of strokes. 2 years ago, and Sarah is her home caregiver.
Mhm.
We have been noticing psychological and cognitive decline in my Aunt Sarah as she deals with the stress of daily activities you and I would find mundane. We have noticed declining coping skills, and we feel they are exacerbated by both medical complications as well as some congenital challenges Sarah has always lived with. My mom has been attending weekly counseling sessions with my Aunt Sarah for about 9 months now, and my mom had a conversation just this week with the therapist that this type of talk therapy isn't fitting the bill for what Sarah needs. It resulted in a referral for a psychiatric evaluation. She doesn't grasp, understand, or connect to her emotions anymore. Her ability to comprehend emotions in herself and others is devolving rapidly. We have been actively trying to navigate this as a family to get Sarah the help she needs to function, but we have reached the end of our capabilities, but not our desire or persistence. We are asking the court to help my aunt get the resources available to help both her and us. We now have a vulnerable elder to figure out care for in Jean Bowling, but it now appears we have another vulnerable adult needing care in Sarah. This is a very difficult time for our family, as you can see, but we are a family built on love and persistence, and we welcome any help the court can help navigate this. Thank you, Your Honor.
Now, it looks to me that Mrs. Bowling there is injured. Do you know what happened to her?
I don't, Your Honor.
Okay. difficult situation. All right, Miss Bowling, I'm going to release you. Conditions of your release: don't violate the law, don't possess any firearms or dangerous weapons. At this time, I'm not issuing a no contact order. I think for pretty clear reasons. But if there's any problem between now and the resolution of this case, there may need to be an order put in place if there's any violence. Amy, let's have a pretrial with the public defender. All right, Ms. Bowling, October 22nd at 10:30 will be your court date, and the public defender will be helping you through this. Okay, Ms. Bowling, you are good to go.
Attorney. Okay. And this is going to be her attorney's assistant. This is who you'd want to reach out to schedule with our office. Okay. 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 Thank you. Thank you, guys.
Thank you, ma'am. Okay, and we'll go back over to the jail now. Ms. Day, is that Mr. Bartlett?
Hello, Your Honor. I'm here with Mr. Erwin Bartlett for a trial confirmation hearing. You just submitted a motion to request a competency evaluation. It has been filed and served. However, it was just done, so there is a copy in the courtroom for you as well as a proposed order for your review.
Yes, Ms. Myers just handed that up on your behalf.
Ms. Myers.
Oh, yeah.
We'll clear it up for you. Okay. I'm going to take a quick look here at Mr. Bartlett's other cases in Superior Court. I can't recall if there were any orders for competency in those cases.
My understanding is that one has not yet been requested.
Yeah, that's what it looks like here. I don't see a notation that any proceedings have been stayed.
I am in
Okay.
contact with his other attorney, and we both indicated likely interest in submitting a request for an evaluation.
Yeah, that's what I have right here. Yeah. So this would necessitate a stay, and it would also it would have the effect of canceling the trial date on October 1st. State have any position?
No objection.
All right, Amy, cancel the trial date. We're going to set this for a competency hearing. I'm signing an order for a competency evaluation. And dates. Ms. Day, how about October 10th for competency hearing?
Yes, that works for me, Your Honor.
Okay. At 1:30. All right, I've signed the order for a competency evaluation. We'll file that right away. And Mr. Bartlett, we will see you next on October 10th.
Thank you, Your Honor.
You're welcome. Got it. Okay, let's cut over to Nisqually again. And over at Nisqually, what's your name, please?
My name's Kennedy Harris.
Okay, Ms. Harris, today you are in court for your arraignment on a charge of malicious mischief and attempted theft that the city of Lacey alleges occurred on September 18th. Mr. Swenson.
Yes, Your Honor, I spoke with Ms. Harris before court, reviewed the nature of the charges and her constitutional rights. She has no questions. At this time, defense will stipulate to probable cause for the purpose of today's hearing only and ask to enter not guilty. And Ms. Harris was or is represented by my office on the backup case, so I'd ask the court to appoint us on this new case. She is qualified for public defense. Thank you.
All right, Ms. Harris, I'll appoint Pacific Point to represent you in this new case as well. Enter your plea of not guilty to both charges. I am Mr. Sharp, the city's position on conditions.
Thank you, Your Honor. City's moving to revoke the SOC on the case ending in 9863 based on this new law violation. I don't see any warrant or criminal history that would justify a bail request today. So city's just asking for conditions of law-abiding behavior. They should not return to Safeway in Lacey.
Okay, Mr. Swenson.
No objection. I reviewed those conditions with Ms. Harris. Shouldn't be any issue.
All right, then, Ms. Harris, I will release you today on this case. While the case is pending, don't violate the law and don't go to Safeway. And then I'll give you a court date to come back for both cases. So, Lacey pretrial out of custody. Okay. All right, your court date is October 28th at 10:30. Okay, Ms. Harris, that's all for today, and we'll see you next month.
Yeah, I think that concludes the Lacey calendar for this afternoon. So thank you very much. Have a nice day and a nice weekend.
All right, have a nice weekend.
Thanks, everybody. Have a nice weekend.
Mr. Stashevsky.
Good afternoon, Your Honor. Present with me is Mr. Philip Pollock, number 13 on the calendar, Your Honor.
Yes. And Mr. Pollock, good afternoon, sir.
Going.
And I see that, well, we're here for trial confirmation, but I see you've submitted a guilty plea.
Right. Yes, Your Honor. The intention is to enter a disposition in this matter today.
All right. So first of all, Amy, the charge is amended per the complaint that the state filed September 5th to DUI. And it looks like he's pleading guilty to that charge. All right, Mr. Pollock, I do have your guilty plea to the charge of driving under the influence. Have you reviewed your guilty plea with Mr. Stashevsky?
Right, sir.
Okay. All right, you're waiving your legal rights in this case by pleading guilty to that charge. So that means the right to go to trial, the right to have the prosecutor prove the charge beyond a reasonable doubt to a jury, the right to call witnesses who could testify in your defense, the right to hear witnesses testify against you and question them. You're giving up the presumption of innocence and the right to appeal your conviction to a higher court. The maximum sentence for DUI in this case is 364 days in jail and a $5,000 fine. And no matter what sentence the prosecutor is recommending, I could impose up to the maximum.
Okay.
There are also mandatory minimum penalties. And those are based on prior offenses and the current case. And it looks like in your case, the you and the prosecutor apparently agree you have 2 prior offenses within the last 7 years. So they're recommending a total of 210 days of confinement, and believe that's right. There's also a mandatory fine, but that can be waived if you're indigent. And then there's also a mandatory driver's license suspension that'll be issued by the Department of Licensing. So do you have any questions about the mandatory penalties for a DUI?
No, sir.
All right. And Mr. Pollock, did anybody make any threats or promises to get you to plead guilty?
No, sir.
All right. And the statement that you've written here on your plea form, it says on August 6th of 2025 in Thurston County, I drove a motor vehicle while under the influence of intoxicating liquor. Is that your statement?
Correct.
I will accept your guilty plea. All right, Mr. Lindgren.
And Your Honor, this is a guilty plea with an agreed recommendation, or I was a latecomer to this calendar.
Yeah, it was. I noticed it wasn't you who signed the guilty plea statement.
This is a agreed upon resolution I worked on with Mr. Weston. Mr. Lindgren.
I thought so. I just wanted to thank you, counsel. The state would ask the court to follow the agreed recommendation. It was well negotiated between the parties, Your Honor.
So with, I guess one fact that I didn't get as part of the plea conversation was either whether this was a refusal or whether this was a breath test of 0.15 or higher.
Your Honor, sorry. I'll actually defer to the state.
I happen to take it out here right now. It looks to have been a breath test over 0.15. Yeah.
Over 0.15.
Yeah, I've got 0.182 to 0.196.
Okay. All right. So then you may be off on what the mandatory sentence would be under these circumstances. So his prior offenses were in 2018 and 2021, both within 7 years of the offense date alleged in this case.
In Your Honor, Mr. Weston and I had negotiated an agreed upon resolution to 2 priors with either the BAC no test or under 0.15. If we were by the law obligated to do the higher, defense would not want to.
No, you're not.
Okay.
No, you're not. If the allegation is going to be a no test for purposes of the factual basis of the plea, then that's what it'll be.
Yeah, this will be a no test.
Okay, gotcha. So, okay. All right, Mr. Stashevsky.
Thank you, Your Honor. There are kind of numerous representations I'd like to make in Mr. Pollock's case. First, as I think might be somewhat evidenced by the change in filing, Mr. Pollock's case has been somewhat of a fluid process in that there was some evidence that both sides were seeking. Even with that evidence, Your Honor, Mr. Pollock has permitted me to share that I believe there were very viable trial approaches to this case. But Mr. Pollock has been consistent with me throughout our time together that he really wants to focus on treatment and getting help for his substance use disorder. He has been unwavering in the focus on that component of it. And to that end, Your Honor, I had a substance use evaluator complete an in-custody substance use evaluation for Mr. Pollock, and that should be available to Your Honor and filed with the court. It recommended intensive inpatient. I worked with the substance use evaluator and with the and got a start bed date, and that letter from American Behavioral Health Systems could also be available to the court date. It has a start date of October 9th. I can represent to the court that with the agreed upon resolution, I do believe Mr. Pollock may be out approximately October 4th. So I can represent to the court that I will be communicating with the substance use evaluator, who's been a great help facilitating these communications, as well as Ms. Gutierrez, who is the author of the ABHS letter, and confirming that with the agreed upon resolution, Mr. Pollock would not be in custody on October 9th, I believe, and that he would need to be there on October 9th. But we do have a firm start date, and Mr. Pollock is looking forward to getting that treatment, Your Honor. A couple other things I'd like to highlight. Mr. Pollock, for the past month, has attended the AA meetings in the correctional facility every Wednesday. So as of today, Your Honor, he has attended 4 of those meetings. He also started attending 2 weeks ago the 33rd group, which is a group that meets in the correctional facility that has a focus on spiritual supportment and mental health. And he has attended 2 of those sessions as well. He also relates to me, Your Honor, that he has completely read a Narcotics Anonymous book that was available here at the correctional facility, which again, I think does evince the sincere desire on his part to get treatment for the substance use disorder, Your Honor. And I appreciate the court's time in letting me share all that contextual information. I do think it was important in this particular case to convey all of that.
All right, and Mr. Pollock, would you like to say anything before I sentence you?
I know it was a mistake and I just want to get help and better myself and get back out to my daughter and family and change. And make change for the better and keep my head on a straight path and never go back to alcohol or anything again. So.
All right, well, I saw the letter from ABHS before I came into court today. So I had a pretty good sense that that was the direction that you were heading toward, going into an inpatient program and dealing with your addiction issues and trying to, transition, I guess would be a good way to put it, from the kind of sobriety you get when you're in the jail versus the kind you maintain yourself when you're out of the jail.
Right.
And I think that's the way to be thinking. That's the right way to be thinking about your situation so that you can maintain that once you get released.
Correct. And also I'm going to be, after I complete the inpatient program, I plan on becoming an outpatient as well and continuing in the program just to keep bettering myself for further future. So.
Yeah. Well, Mr. Pollock, you got a lot of DUIs in a real short period of time, and you're still a really young person. So there's really a lot of reason for you to change everything, change your approach to your addiction and your sobriety, because your life can be so much better. And you have a lot of life ahead of you.
Correct.
Yeah. All right. Well, Mr. Pollock, I think this, makes sense. I think Mr. Stashevsky's done a really good job for you to get this, to help you get this organized.
Yes, sir.
So I'm going to follow the recommendation that the attorneys are making to me. So that means that your sentence for the DUI will be 364 days, 154 days are suspended. You have credit for 45 days served since you were arrested. That leaves 45 days of custody in the jail to do, minus any good time you get from the jail, and 120 days of EHM. As far as financial obligations, the only thing I'm going to impose is a probation fee of $120, and then I'm waiving all the fines and costs. For the next 60 months, the conditions of your probation are: don't violate the law, don't drive without your interlock, don't go to bars or taverns, don't drive without your license and insurance, no alcohol, marijuana, or non-prescribed drugs, and don't refuse a breath test. And then the most important part is to follow through with your substance use treatment, complete that, and do 1 session of the DUI victim panel.
Okay, correct.
Have any questions about that sentence?
So how many days from now do I have left? That's what I'm curious about.
Well, the final determination is made by the jail, and that's going to be based on any good time you've earned.
Okay. Okay.
Okay.
Okay. That would be it. I appreciate it very much.
Okay. Well, good luck at your inpatient program.
Your
Thank
Honor,
you.
real quick before we wrap up this matter, for as far as a scram device for Mr. Pollock, the state wanted to make the ask that scram remain a condition at least until we have treatment reports after his release.
Okay. That's okay. Let me ask you if you know, Mr. Stashevsky, is that going to work with ABHS if he were to have a scram? I don't want them to be involved.
The two responses I could offer was this was not a term that Mr. Weston and I had discussed prior to today. And then the second and the most direct answer to your question, Your Honor, is I do not know. I'm just
after.
What's
I don't mean to present it as part of the agreed recommendation.
Yeah, so I see what you're saying there. I think at this point, since we're pretty confident he's going to transition directly from the jail to ABHS, I'm not going to require the scram.
Understood. Thank you.
All right. Thank you, Mr. Pollock.
Great day. Thank you.
Thank you, Your Honor.
And then over at Nisqually, ma'am, what's your name, please?
Elizabeth Pippen, hello, Mr. Wow.
How you doing, Miss Pippen?
Not great. You guys have the wrong birth. You have the wrong name on here. As you have Elizabeth K. Aloha, and my legal name is Elizabeth Ellen K. Aloha. It's on my driver's license, on my ID. So you guys have the wrong name. So that means it's been, and I've been in here since I was arrested. I haven't even been arrested. All right, and I've been here ever since because I couldn't pay my 500, which I am.
Well, hold on just a minute, okay, Miss Pippen? I'll get back to you in just a couple minutes, all right?
Oh, okay. I thought you were talking to me. I'm sorry.
Yeah, I was, but now I'm going to go and talk to Mr. Pazderka about you. So listen up, okay? Listen to him, Mr. Pazderka.
Your Honor, it appears there was some mix-up in communication with DSHS. Ms. Pippen was released and then found herself back in custody, and so the DSHS is saying, at least they told us that they need a new order to be able to come back and evaluate her. Basically,
I don't need evaluation for anything.
Order is not.
I have never been charged with anything. I don't know you. I've never been charged with
Miss
anything.
Pippen, don't interrupt, okay? Just hold on.
Please give me a break.
So.
Never been arrested for anything. I have no charges on me. I don't.
Just wait. Just wait.
No, sir. I've never talked to that man.
So, Your Honor, the request is set this over, and I will be submitting an updated order for the court to sign.
For what? I have never been arrested. I don't have charges on me. What am I being arrested for? I'm not even been arrested.
Miss Pippen, hold on, okay? Please, just be patient. I promise you I'll get back to you. All right, Mr. Lindgren, Miss Pippen's been in custody for a while.
Yeah.
We need to hold her in custody. Is
For
the
what?
city, does the city want to continue to have
They
her
have the
held?
wrong name. You have the wrong name. That's void. That is void. That's not me. Wrong name. The whole name wrong. On my check on my ID, check everything. It's the wrong name. You have the wrong name. You cannot hold me with the wrong name. And I've been here this whole time with the wrong name. So that means like major penalties. I mean, please do not disrupt my legal knowledge. All right, I'm way smarter than you legally. I guarantee you, I've got 4-year degree legal. 4-year degree.
Your Honor, are you referring to possibly changing the conditions of release?
But I have never talked to that man. This is the first time I've ever seen anybody, and I've been held here. Okay, so either I'm going to get my own private lawyers again, or do it myself.
Ms. Pippen, please hold on. Please
Commissioner
hold on.
Moxley, you
Right, Mr. Pazderka, I'm gonna release her for a out of custody evaluation.
Thank you, Your Honor. I will submit an order to that effect.
I'm gonna pick a date for that here, and we'll put it on the regular out of custody calendar. Let's look at December 12th. Amy, can you give me a time on December 12th? Okay. All right, Ms. Pippen, your court date is going to be December 12th at 9:30. And you're released until that. All right, I appreciate you going back and looking at that, Mr. Lindgren. I noticed you've been in custody since August 17th.
Thank you for pointing it out.
Okay, Ms. Pippen, we'll see you in December and you're released. All right, there's more.
Good afternoon, Your Honor. I have with me Mr. Germaine Green.
Yes, Mr. Green, good afternoon, sir.
Good afternoon.
And we,
All right, and pre-trial hearing today?
pre-trial hearing, Your Honor, we are just requesting to maintain future dates. And if the court would hear conditions, I know Mr. Green would like us to be heard on conditions, but I've advised him that we will likely need to file something and get that on Tuesday. However, if the court's open to hearing it, we could discuss, we could address.
That's correct, Mr. Green. Ms. Moore did not lead you astray there. There's a way this works and she knows how that works, so you should rely on her for that. Okay, so confirmation is set for October 24th at 10, but we may be hearing this case sooner depending on motion for review of release conditions.
Yes. If we do get Tuesday, that would be great.
Okay, thank you, Mr. Green.
All right, thank you.
Am I mistaken, or was that the last of the in-custody
Your Honor,
cases?
if I could just momentarily recall Mr. George Flores's case, just for some clarification purposes, not necessarily about any conditions of the case. The requirement to provide the proof of surrender before he gets released.
Yes.
I just wanted to clarify. So the two guns that he does own were both taken as evidence. We went over to the sheriff's desk to talk to them. We cannot provide receipt or proof of the surrender, as it wasn't surrendered, it was taken into evidence. We would need the proof of the receipt. I reached out to Mr. Fortunato, who reached out to individuals at the sheriff's office, and they said that a non-surrender would be okay since they were taken into evidence. I just wanted to make sure that that's actually done.
Yeah.
Okay.
He should file a declaration of non-surrender if the firearms that he does own were already taken by law enforcement.
And they have been, and I can do that. We have that ready now.
Yeah, that's fine.
So, okay, great.
Yeah, if that's the case, then yeah, you can file that, and that would be compliance with that order.
Perfect.